If you are a National Guard, Reserve, or Coast Guard veteran, and your time overseas was a short tour, a temporary duty assignment, or a few flights through the region, you may wonder whether the PACT Act's presumptive conditions apply to service as brief as yours. That question is one of the most common reasons part-time veterans with real toxic exposure never file the claim they are entitled to. Here's what the law actually says. The PACT Act of 2022 promised to address comprehensive toxics. Presumption is based on where you were, not how long you were there. A 12-month deployment and a single flight through covered airspace are treated the same way, but the presumption has a second requirement, and it decides most part-time claims. Your presence has to have happened while you were on federal active duty. Two questions then. Where were you, and what duty status were you in? So by the end of this video, you will know which locations, dates, and duty status the presumption covers, why short tour and aircrew presence is often missing from the records the VA checks, and how to document your own presence so the presumption applies to your claim. So the first thing to establish is what the presumption actually covers. Many part-time veterans assume the PACT Act was written for the members who spent a year on the ground at a large base, and that a short assignment or a few missions through the region does not rise to that level. The law makes no such distinction. Under Title 38 of the United States Code, Section 1119, if you served in a covered location during the covered period, the VA concedes you were exposed to toxic hazards. It does not measure the length of your stay, 12 months in Iraq, or a single 48-hour cargo mission through covered airspace. Your presence activates the presumption. What the law does measure is your duty status. Section 1119 covers a veteran who performed active military, naval, air, or space service in one of those locations. Title 38 of the Code of Federal Regulations, Section 3.6, defines that term, and for a Guard or Reserve member, it means federal active duty. So deploy on a Title 10 mobilization, and the presumption reaches you. Fly that same mission in a drill status or on a state Title 32 order, and it does not reach you the same way. We covered that difference in an earlier video. Here the rule is short. Your presence counts when your orders were federal. The covered locations fall into two periods. Service on or after August 2nd, 1990 covers the Gulf countries, including Iraq, Kuwait, Saudi Arabia, and Somalia. Service on or after September 11th, 2001 covers Afghanistan, Djibouti, and the surrounding countries. Both periods include the airspace above them, and if you served aboard a vessel, the Southwest Asia theater definition at Section 3.317 also reaches the Persian Gulf and the surrounding waters. The complete list, with every country, date, and covered condition, is in the tool below. The presumption works like a passport stamp. You receive the stamp for entering the country, whether you stayed a month or passed through on a 2-hour layover. Crossing the border is what activates it, not the time you spent inside. So your claim turns on two facts: that you were physically present in a covered location during the covered period, and that you were on federal active duty when you were there. Pair those with a current diagnosis of a covered condition, such as asthma, chronic rhinitis, chronic sinusitis, or one of the covered cancers, and the service connection follows. So proving your presence should be simple, since you were there. But here is where part-time veterans with genuine exposure see the claim denied. You file, and the VA responds that there is no record placing you in a covered location. That denial is a records problem. Section 1119 tells the VA to look first at an exposure tracking record system, which today means the individual longitudinal exposure record. The VA reads it alongside centralized federal deployment data. When an active component unit deploys, its presence lands in that central data. Your service is often recorded differently. Short tours, temporary duty assignments, and aircrew missions are frequently administered by your own wing or readiness center. The orders, flight logs, and crew manifests that prove them can stay in those local files without ever reaching the central data. And when the central data does not show your presence, the VA processes your claim on what it can see. Your local file is like a deed recorded at a county office that was never copied into the state database. Search the state database and the deed does not appear, not because it never existed, but because it is sitting in the county office. Section 1119 already accounts for that gap. It says that when the exposure tracking record does not show the exposure, the VA may consider the totality of the circumstances of your service. That is your opening. You are not arguing against the record. You are supplying the part of it the central data never received. So you gather your local records, and they do not all prove the same thing. Some only name where you were ordered to go. Others prove where you actually were and in what duty status. You want as many of the second kind as you can gather. Start with your orders, your mobilization and temporary duty orders. Name the destination, the reporting dates, and the authority you served under. That authority line is what most veterans overlook. It is what shows you were on federal active duty, which is the status Section 1119 requires. Confirm it is written on the orders themselves. Your travel vouchers are the stronger proof of presence. They show the actual movement, the flights, the dates, and the per diem paid for being in that location. That makes them the VA's own financial record that you were physically there. And if you were aircrew, your flight logs and crew manifests place you in the covered airspace mission by mission with the tail number, the route, and the date. Then obtain your point statement, which shows every day you were in a paid federal status. For the Army National Guard, it is the NGB Form 23, and each component has its own version. It confirms you were in an active federal status during the exact months of that deployment or temporary duty assignment. Finally, pair those records with a current diagnosis and state your case plainly in the claim. Name the covered condition, the covered location, the exact dates, and the federal active duty authority you served under, referencing the orders, vouchers, and point statement you attached. That gives the VA the proof of presence, and the proof of status the central data did not. You don't have to guess whether your service is covered. We built you the PACT Act presence checker. Put in where you were, the dates, your duty status, and the condition you're claiming, and it tells you whether all three fall inside the covered period, then hands you the exact records to prove it. It's built, it's waiting, it's yours. Use it. Before we close, nothing here is a promise of any particular rating. Every claim is different. What we give you is the cleanest way we know to execute. For Guard and Reserve, women veterans, step by step, the frameworks that tie it all together, or benefits news, subscribe to the channel that fits your fight. That is how you make the presumption apply to your service. Next, your VA compensation and pension examination. How it works when the VA sends you to a third-party contract examiner, and how to communicate the full functional impact of your condition so the exam reflects what you actually live with. Unlock your file, claim your status,